Everybody ready? We're just waiting for everyone to connect. So members and staff and members of the public, welcome. We have received a apology from the chairperson. So as per standing rule 82.3, in the absence of a chairperson from a meeting, the committee must elect one of its members to be an acting chairperson at that meeting. So we will open up for nominations now.
Coordinator, I would like to propose Mr. Reagan Allen.
Thank you. Case.
Thank you, Coordinator. I also propose that Honourable Member Regan Allen chair the meeting. Thank you.
Okay, Member Allen, you may take your seat. Thank you.
Good morning, Ms. Kamish Ahmed.
Good afternoon, Member Badman.
Thank you. Sorry, I just wanted to let you know that I'm an alternate member today here, standing in for Member Mackenzie. Thank you so much. Bye.
Thank you. Noted. Thank you.
Good afternoon, members. For those that are also joining online, members of the public, the department, my name is Regan Allen, and thank you to Member Dagmore and Member Brunkhuis for the nomination to be the acting chairperson for today. We have noted Member Deidre Baartman standing in today. We are also just waiting for one member, Member Wendy Philander, to join in. We are currently experiencing some technical difficulties. For those that are online, our public hearing is being broadcast on YouTube as well as on social media platforms. As a committee for the Premier and Constitutional Development, our mandate is to maintain oversight of the relevant authority and its public entities, but also in fulfillment of that mandate is to ensure that public participation is effectively done in our province, and that means that there's involvement in the legislative process that is coupled thereto. So once again, members of the public that are joining online, the departments, members that are here, thank you for your attendance. I will allow members to introduce themselves for the record.
Thank you, Chairperson. It's Cameron Dugmore, a member of this committee. If I could just use this opportunity to ask you, Chair, how do we see which members of the public have joined? And I would just like to ask that question because, as you know, we've made an attempt where some people have wanted to access this either from a two-song center or Cape Access or even getting data to join this. So is there any way we can know how many or who they are? Thanks.
Thank you so much, Member Dagmore. I will reply to you directly after the next member introduced himself.
Thank you, Chairperson. Khalil Brunkhuis.
Thank you so much, Member Dagmore. We have to my left as well our procedural officer. I will allow our procedural officer at this time to just give clarity on who is online and requests that have been received via the administration.
Thank you, Chairperson. I see that there were two members of the public that asked to join and they are being kicked out every time. So we're just trying to connect them, which is Miss Melanie, and there was, we just saw two other names, Peter van Sale and Zolani. So we're able to see who's online, but I see Miss Melanie is being kicked off every time.
So our IT is trying to assist in that regard. It is also being streamed on social media and YouTube at this stage. We will commence with our public hearing on the first amendment bill for the Western Cape Constitution. We have had public hearings in the province already. This is the Cape Town one, and with us we have the Department of the Premier, as well as the Department of Environmental Affairs and Development Planning. I will allow the Department of the Premier to introduce themselves. Directly there afterwards, the Department of Environmental Affairs and Development Planning.
Good afternoon. I'm Clara Williams. I'm a State Law Advisor, Department of the Premier Legal Services.
Good afternoon, Chair. Good afternoon, members of the public. Ayub Mohammed, Chief Director from Environmental Affairs and Development Planning.
Thank you so much to members of the public and those in attendance. Like Member Dagmo stated, we wanted to foster public participation in a meaningful way in order.
My understanding is that there are other officials here, that there was only one official who introduced himself. So are they all going to introduce themselves?
We can all introduce ourselves.
I think so.
Paul Hardcastle, also Environmental Affairs and Development Planning, Director, Policy and Planning Coordination.
Hi, Liesel, member of the public, commenting on the EC position repeal.
Good afternoon, Michael Tishievsky, also a member of the public, just commenting on the Environmental Commissioner Bill.
Good evening. My name is Sarfaraz Mukaddam. I'm just a member of the public. I'm here to observe.
Mark Wiley, member of the public, and I'll make a presentation on the amendments.
Afternoon, Rian Smith, representing an NPO called the Concerned Federalists.
Frank Raymond, I'm also here on behalf of the Concerned Federalists. Thank you, Chairperson.
Could I just ask the last two gentlemen, did they say Concerned Federalists? Was that the name of their NPO?
As you can Google us, we're Concerned Federalists. Besorgde Federaliste in Afrikaans.
Besorgde Federalists.
Uiters besorgde Federaliste.
Okay. 100%. Dankie.
Good afternoon, members. I'm Sivulo Mazanza. I represent PMG, Parliamentary Monitoring Group. Thanks.
Thank you so much. I have also noted that
I'm sorry, Chair.
Members online will now introduce themselves. And I trust that our IT issues that we've experienced earlier would have been sorted out. Members online, are you able to introduce yourself for the record?
Mireille Wenger.
Member Makambo Kocha.
Thank you so much. If there's any member of the public, are you able to introduce yourself for the record? I see a gentleman whose video is on. If I can request that videos are switched off at this time in order to preserve and any other member that potentially is having IT issues.
So the last gentleman, did I hear correct? Is that Parliament Monitoring Group? Okay.
We will be commencing, and as we will attempt to get the gentleman whose video is frozen at this time. But members of the public, those are online, thank you so much for your attendance here today. Like I've indicated, is we are here to obtain a briefing from the Department of the Premier as well as the Department of Environmental Affairs and Development Planning. You have a question, sir?
Just a comment that the head of department, Piet van Zyl, is also online.
That's duly noted. Thank you for everyone that introduced themselves. It will potentially be remiss of me to not acknowledge Mr. Mark Wiley, the former Chief Whip of this House. So thank you for your attendance here as well. I will now hand directly over to the department, but once again state to members and to those online and the public that we have exercised our oversight role in our public participation process. We have advertised extensively in the August, the Burger, Bukani, George Herald, Mossel Bay Advertiser, the Neisner Plate Herald, all the mayor's office across the Western Cape, municipal managers, speakers, mod centers, the Tusang centers, as well as community development workers and at universities. In order to facilitate meaningful public participation, we are further via our public outreach and education unit informed the public and its stakeholder database. Also, Dear SA is another platform that was used, and there is an estimated 1 million stakeholders on Dear SA's database. So on that note, I will now hand directly over to the Department of the Premier to do their first briefing. Thereafter, we will obtain a briefing from the Department of Environmental Affairs and Development Planning, and then we will proceed from there.
Good afternoon, Acting Chairperson, members of the Standing Committee and members of the public. My name is Clara Williams. I'm a State Law Advisor in the Department of the Premier Legal Services. My presentation will deal with the technical amendments to the Constitution of the Western Cape. I am just waiting for the procedural officer to assist to show my presentation. If you could just bear with us, please. The National Constitution was assented to in December 1996 and commenced in 1997, and a year later the Western Cape Constitution was assented to and commenced. The Provincial Constitution provides that its provisions must not be interpreted as conferring any legislative or executive authority on the province which is inconsistent with the National Constitution. The National Constitution has been amended 17 times. However, no amendments have been made to the Provincial Constitution yet. An analysis of all these amendment acts was done, and it was found that concomitant amendments to the Provincial Constitution were required. The Constitution of the Western Cape First Amendment Bill aims to firstly amend the Constitution in order to align it with the amendments that were made to the National Constitution, and secondly, to repeal the provisions dealing with the Commissioner for the Environment. The proposed technical amendments to the Provincial Constitution will align it with the relevant amendments to the National Constitution to avoid inconsistencies and difficulties with interpretation. This slide indicates which sections of the Provincial Constitution are proposed to be amended and what their National Constitution counterparts are. The amendments relate to membership of the Provincial Parliament, the calling of dates for elections, money bills, interventions in local government, taxes and loans. In addition, expressions used in the National Constitution will be taken over in the Provincial Constitution, and certain phrases in the isiXhosa text will be replaced. The slides that follow compare the wording of the National Constitution as amended on the left to the wording of the Provincial Constitution if the bill is enacted on the right. Wording on the right, in bold and square brackets, indicates proposed deletions, and wording that is underlined indicates proposed insertions. The proposed amendment to Section 15 of the Provincial Constitution will align it with Section 106 of the National Constitution and will result in a person losing membership of the provincial legislature if he or she ceases to be a member of the political party that nominated him or her as a member of the legislature. The amendments to Section 106 of the National Constitution took effect in 2003 and 2009. The proposed amendment to Section 17 of the Provincial Constitution will align it with Section 108 of the National Constitution. It provides that a proclamation calling and setting dates for an election may be issued before or after the expiry of the term of a provincial legislature. Section 108 of the National Constitution was amended in 1999. The proposed amendment to Section 30 of the Provincial Constitution will align it with Section 120 of the National Constitution by extending the definition of a money bill. Section 120 of the National Constitution forms part of Chapter 6, which deals with provinces. The amendments to Section 120 of the National Constitution took effect in 2002. It is important to note that in terms of the National Constitution, the provincial government was already from February 1997 empowered to impose taxes, levies, and duties. In 2001, National Parliament passed the Provincial Tax Regulation Process Act 53 of 2001 with the aim to regulate an intergovernmental process that must be followed by provinces when exercising their power to impose taxes, levies, duties, and flat rate surcharges. The proposed amendments to Section 49 of the Provincial Constitution will align it with Section 139 of the National Constitution. The National Constitution was amended in 2003. The proposed amendments are quite lengthy, so I will simply show the slides relating to Section 49 of the Provincial Constitution. The proposed amendments to Section 59 of the Provincial Constitution will align it with Section 228 of the National Constitution by simply deleting the references to the term tax basis. The amendments to Section 228 of the National Constitution took effect in 2002, and the phrase had no definite meaning in the context it appears in. The proposed amendments to Section 63 of the Provincial Constitution will align it with Section 230 of the National Constitution. The amendments to Section 230 of the National Constitution took effect in 2002. The obligation to repay loans for current expenditure within 12 months was deleted. Lastly, certain expressions used in the National Constitution are proposed to be taken over in the Provincial Constitution, namely references to the Chief Justice instead of to the President of the Constitutional Court, and correct references to the Afrikaans language in the Xhosa text. The repeal of sections 71 to 77, which deal with the Commissioner for the Environment, will be dealt with by my colleague, Mr. Ayub Mohammed from the Department of Environmental Affairs and Development Planning. Thank you.
Thank you so much, Ms. Williams from the Department of the Premier. We will go straight over to Mr. Mohammed.
Good afternoon. Thank you, Chair. Firstly, I must say that the presentations that you have in the pack is a longer version of the presentation that I will be presenting, but I will indicate the sections as we go along because this is an abridged version of the presentation that we'll be doing. So thank you. Good afternoon. Goeiedag, Molweni. Okay, it's being presented then. So the presentation covers the following: the background and the status of the Commissioner, the history of the amendment process to date, the functions and the duties of the Commissioner from the Constitution of the Western Cape, the Department's response to the duties and functions in the context of the prevailing legislative regime, what the Commissioner will cost, and a conclusion. In terms of the background and the status, now Section 71 of the Provincial Constitution establishes the Commissioner for the Environment. Section 72 to 77 deals with the powers and the functions of the Commissioner and related aspects. And then the Commissioner is binding on the provincial legislature and the executive unless and until the relevant sections are repealed. And that is what is currently under consideration. Now, the Provincial Constitution may be amended if it is determined that the Commissioner is no longer desirable, and the Department of Environmental Affairs and Development Planning is of the opinion that it is undesirable for the following primary reasons, and we'll elaborate on that as we go through the presentation. It will result in a duplication of roles and responsibilities. It will consume scarce state resources, and it will not address any governance gaps. In terms of the history of the Commissioner to date, in 2001, a draft bill for the Commissioner for the Environment was produced, and that included an organizational design, the definition of the environment, which is exactly the same as the definition contained in the National Environmental Management Act. And it also defined environmental administration as any act, omission, or decision by an organ of state which significantly affects the environment in an adverse manner. In 2009, an external legal opinion was obtained on the desirability of appointing the Commissioner. Now, it confirmed the legislative reforms that occurred, which we will refer to later on. However, it also indicated that an amendment to the Constitution should not be taken lightly, and that consideration should be given to amend the Constitution to appoint a Commissioner when it is appropriate or desirable to do so. But that did not proceed. We did not determine when it will be appropriate or desirable. Since 2010, the amendment of the Western Cape Constitution proceeded on that basis. In 2015, further analysis was confirmed that the duplication still exists, and that bill of 2001 was then withdrawn. In 2019, the 5th Provincial Parliament of the Western Cape, the one that preceded this Parliament and this committee, dissolved, and the bills that were in place lapsed. So the Commissioner for the Environment has never been appointed. And the current Provincial Parliament, which is what this hearing is about, has reintroduced the bill with a provision to repeal Section 71 to 77. We're now going on to part 3, if you're following in the presentation that is in front of you. So we're turning to the duties and the functions of the Commissioner as stated in the Provincial Constitution. So according to the Constitution, there is a Provincial Commissioner for the Environment who must monitor urban and rural development, which may impact on the environment, investigate complaints in respect of environmental administration, and recommend a course of conduct to any provincial organ of state or municipality whose activities have been investigated. And we'll come back to the provincial organ of state and municipality as it's stated in the Constitution. Now, the Commissioner must act in accordance with the principles of cooperative governance and intergovernmental relations. The Commissioner has additional powers and functions as may be provided for in provincial legislation, which has never yet been enacted. So there's no provincial legislation in place. Now, where the Commissioner has made recommendations to a provincial organ of state, that organ must report to the Commissioner on its actions within a reasonable time frame. And the Commissioner must also monitor the implementation of its recommendations by that provincial organ of state, not municipalities, only provincial organ of state. Now, the Commissioner must report annually to Provincial Parliament, and it must also submit its recommendations to the Provincial Parliament, and it is required to report to the Provincial Parliament at any time, as requested, we would assume. The Premier appoints the Commissioner, and that nominated by a Committee of Parliament. So a Committee of Parliament must be established who will appoint the Commissioner, will nominate the Commissioner. And that nomination must be supported by a 60% vote of the Provincial Parliament. So Parliament must make the nomination and it must be supported by 60% of the Provincial Parliament. But civil society must be involved in the nomination process. The Commissioner is appointed for a period of 3 years, renewable once, so 6 years in total. Now, the Commissioner may be removed from office on the grounds of 1, misconduct, 2, incapacity, or 3, incompetence. But this can only happen if found to be so by a committee of the Provincial Parliament and a resolution of the Provincial Parliament calling for the Commissioner's removal with the supporting vote of at least 2/3 of the members of the Provincial Parliament. So that another process will have to be conducted by the Provincial Parliament to remove the Commissioner. The Premier may suspend the Commissioner while that parliamentary process is underway, and the Premier must remove the Commissioner if the Provincial Parliament so decides. So what is our response to the duties and functions of the Commission? And we're now going to section 4 of the presentation that you have in front of you and that is being displayed. Since 1998, there's been numerous laws along with extensive subordinate legislation aimed at integrated environmental management and governance, spatial and land use planning, urban and rural development, and intergovernmental coordination and administrative oversight that has been enacted. We'll show this in the following slide. So in our opinion, there is an overlap in the functions and the duties of roles of the Commissioner, as this has been provided for in national and provincial legislation since 1998. If you have a look at the slide in front of you, and it's included in the presentation as well, prior to 1998, if you look at the middle column, pre-1997, the first block on top, there were limited laws relating to the environment, as can be seen on the slide. There was only the Nature Conservation Ordinance, the Environment Conservation Act, and then there was the Public Protect Act, and planning was dealt with in terms of the Land Use Planning Ordinance. However, in 1997, we did have the start of the Environmental Impact Assessment regime through the promulgation of the Environmental Impact Assessment Regulations, but that was promulgated under ECA. Since 1998, however, there has been numerous statutes related to the environment that has been promulgated, most notably the National Environmental Act of 1998, and various specific environmental management acts, such as the Protected Areas Act, the Biodiversity Act, the Air Quality Act, the Integrated Coastal Management Act, and the Waste Management Act, etc. Planning legislation included the Spatial Planning and Land Use Management Act and the Western Cape Land Use Planning Act. And in terms of governance, there's still the Public Protector Act, but you also have the Promotion of Access to Information Act and the Promotion of Administrative Justice Act. In the pipeline, there's a suite of draft legislation, such as the National Environmental Management Laws Amendment Bill, or NEMLA 4, the draft Western Cape Biodiversity Bill, the Protection and Development of Agricultural Resources Bill, and the draft Integrated Planning Framework Bill. So there's more legislation in place that will deal with the environment and with planning. In terms of strategic policies governing the environment, there are many policies that have been brought onto the statutes. The White Paper on Environmental Management, for example, the White Paper on Spatial Planning and Land Use Management, the National Development Plan, the Provincial Spatial Development Plan, Integrated Urban Development Frameworks, and then there's also the National Climate Change Response White Paper, etc., and a series of other. Also at the international level, there's the United Nations Sustainable Development Goal, and all these cover various aspects of environmental management. And you also have in 2011, the National Framework Strategy for Sustainable Development 2009, and then the National Strategy for Sustainable Development in 2011. So there's various policies and that has also been brought, strategic policies that has been brought into being that govern the environment. So what is the response to the actual functions of the Commissioner? Now, the Constitution says there is a Commissioner for Environment, and it's our opinion that this function is currently catered for in the National Environmental Management Act that establishes various fora and advisory committees. In the Waste Act, there's also the Waste Management Forums that has been established. There are air quality management forums, advisory committees, and there's also some coastal committees that have been established in terms of these various subordinate legislation, and they are to coordinate and promote integrated environmental management across the spheres of government. The National Water Management Act, for example, also creates catchment management agencies. There's water tribunals and water user associations, and the Spatial Planning and Land Use Management Act also creates municipal planning tribunals that deals with municipal planning decision making. Now, specifically the Western Cape Land Use Planning Act, and if you recall, this act only came into being in 2014 and replaced the Land Use Planning Ordinance that existed at the time. It specifically requires the provincial minister to monitor, the provincial minister for planning and land use planning to monitor, amongst others, urban and rural development, and the protection of biodiversity. Also climate change, etc., water resources, housing, disaster management. Now that the Commission is independent and impartial according to the Constitution, it is our opinion that the Commission needs to give attention to the need to balance the goals of environment and conservation and sustainable development. This function is currently catered for in NEMA, which establishes the sustainable development principles that is applicable to all organs of state. Environmental and planning legislation that creates a regulatory framework for listed and specified activities which may impact on the environment. NEMA also provides for environmental management frameworks, while planning legislation provides for spatial development frameworks at regional and provincial levels. And these all take into consideration the need for sustainable development. Then that the Commissioner is independent and impartial, this function is currently catered for in the Promotion of Administrative Justice Act, which applies to all organs at state, and which states that administrative actions are renewable if it is taken inter alia because of the unauthorized or unwarranted dictates of another person or body, or if the administrator who took it is biased or reasonably suspected of bias. And then the public protector can also investigate any conduct of any organ of state, whether is alleged or suspected to be improper actions or that has resulted in impropriety or prejudice. And the public protector must report on that conduct and take appropriate remedial action. That the Commissioner must monitor an urban and rural development which may impact on the environment. Like I said earlier, this function is catered for in NEMA, that also requires the compilation of state of environmental reports and environmental implementation plans. And as I said earlier, LUPA requires the provincial minister to specifically monitor regional planning and development and also urban and rural development. That the Commissioner must investigate complaints in respect of environmental administration. The National Environmental Management Act also creates the framework for conciliation and arbitration in terms of Chapter 4, and NEMA also creates the Environmental Management Inspectorate, or the Green Scorpions, to deal with environmental transgressions. That the Commissioner is required to investigate actions of provincial organs of state that significantly affect the environment in an adverse manner. NEMA requires that all actions must be assessed prior to the implementation in terms of sections 23 and 24, and in terms of the NEMA regulations, and that's the listed activities. So if any organ of state is going to undertake an action that will have an adverse effect on environment, it will have to undertake an EIA. That the Commissioner, furthermore, that the Commissioner must in fact investigate complaints in terms of environmental management. Where significant pollution and degradation to the environment occurs. Section 28 of NEMA allows for the issuing of directives and also establishes the duty of care principle. And this function is exercised by the Green Scorpions. And NEMA, importantly, it's a very progressive piece of legislation, also allows for private prosecutions by interested parties or by groups of persons who may apply to court for such. Then we also have, specifically in the Western Cape, the Western Cape Monitoring and Support of Municipalities Act, and that empowers the Provincial Minister of Local Government to investigate maladministration, fraud, corruption, or any other serious malpractice, and where a municipality cannot or does not fulfill its statutory obligations. And this is something specific to the Western Cape. Furthermore, the Public Protector may also, in terms of the Public Protector Act, investigate, as I indicated earlier, any alleged maladministration in connection with the state of affairs at any government level or institution. That the Commissioner must act in accordance with the principles of cooperative governance and intergovernmental relations. This function is catered for in terms of NEMA, which allows for environmental management cooperation agreements to coordinate and harmonize environmental policies, plans, programs, and the decisions of various departments that exercise functions that affect the environment. You also have the Intergovernmental Relations Framework Act, which provides for the establishment of intergovernmental coordination structures across all spheres of government, and specifically in the environmental sector. There is the MINMEC, which comprises the National Minister, the MECs, the municipal ExCo members responsible for the environment and the environment-related state-owned entities. There's also MINTEC, which comprises of the Director General of Environmental Affairs and the provincial heads of departments and municipal officials dealing with the environment and also environmental SOEs. And then you also have MINTEC working groups that has been established at an official level dealing with environmental matters across the spheres of government. Then we also have that overall environment and development planning oversight is exercised by the provincial parliament in terms of the Public Finance Management Act, and that includes specific reporting requirements. Where all organs of state are required to quarterly report on their performance in terms of the objectives and targets and the medium-term strategic framework, annual plans, etc. And then you also have the individual standing committees and the members' oversight in terms of their respective portfolios, where they can call on provincial departments to report on matters relating to environment. Now, it is important for us to note that the Commissioner has no jurisdiction to investigate any matters which do not constitute a provincial competence, such as water, forestry, fishery, pearl abalone poaching, crayfish poaching, etc. Those are covered by national legislation over which we as a province have no mandate. It is also important to note that the competence over municipal matters is unclear, as there is no concurrent reporting obligations placed on municipalities, even though the Commissioner could investigate the activities of municipalities. And this has probably got to do with the spheres of government in turn and the constitutional allocation of powers. So while provincial organs of state and must report to the Minister and report to Parliament, municipalities are not required to do so. In terms of costing, what will the Commissioner cost? Now, going back to the 2001 bill and the 2001 organizational design, at that stage, given the few pieces of environmental legislation and the immaturity of the environmental regime, I would say at that time, there was one Deputy Director General, 2 Assistant Directors, and 1 Admin Clerk that was proposed at that time. We do not agree with this, should the Commissioner be appointed. In comparison, you have already, in terms of the Western Cape Constitution, the Western Cape Police Ombudsman and the Children's Commissioner. Both of them are at the Deputy Director General level, and they both have a staff complement of about 12 and probably growing. In terms of costing, you have the table in front of you, but basically it means that should a Commissioner be appointed and using the norm of the Children's Commission and the Police Ombudsman, it will cost about 12 million rand in year 1, 9 million rand in year 2, and 10 million rand in 3. And the startup cost of about 3 million rand is included in the first year of that establishment. So it is our conclusion that national and provincial legislation already provide adequately for the protection of the environment, i.e. it has the enabling provisions. The filling of the vacancy is therefore not desirable because it would involve an overlap and duplication of roles and functions already provided for in national and provincial legislation. It will not address any governance gaps, and it will consume scarce state resources. And then on the ombudsman-like functions of the Commissioner will have very limited power, and some of the issues raised during previous consultations are matters that the Commissioner may not be able to deal with and not matters that the Commissioner can deal with. The Commissioner would not have any power to investigate complaints against national government and private entities. And importantly, also the Commissioner would not be a decision body regarding environmental authorizations, nor would it be an appeal body. And thank you, Mr. Chair. That is our submission. Thank you.
Thank you so much, Mr. Muhammad. Members, you will recall in Mossel Bay, in George, and in Saldanha, we have received valuable input from members of the public, and I'm going to now directly open the floor for public comment. I have received a list of members of the public that wishes to make verbal submissions to the committee today. I have Mr. Michael and Ms. Liesel that is going to kickstart the comments that you will be providing today. Thereafter, we will go to Mr. Mark Wiley, then to Mr. Frank Raymond. Is there any other person from the public in the House today that wishes to make a public submission today? Can I check online if there is any member of the public that wishes to make a verbal submission? Mr. Ali, I note you, sir. Can you confirm that you would want to make a verbal submission? Mr. Ali, are you able to unmute?
Yes, I confirm.
Thank you so much for confirmation. You will be number 4 in line. We will go to Mr. Michael and Ms. Lisa. Thereafter, Mr. Ali, Mr. Frank Raymond, and then Mr. Ali in that order. Members of the public, I will encourage questions or your input. We have our legal advisors from the WCPP online as well. We also have Ms. Clara Williams and Mr. Mohammed from the respective departments. And again, to those that are viewing online and on YouTube, we have further opened up a dedicated WhatsApp line in order to make it easier for the committee to obtain input and questions and feedback from members of the public. So once again, to those that are viewing, thank you so much for being here. I will now acknowledge Mr. Michael. You can take the floor now, sir. Thank you.
Good afternoon. We stand here today to present a case study of a steel mill as our motivation that in the Western Cape we need a commissioner for the environment, or at the very least a watchdog for sustainable development which has a fair balance with the economy, social and environmental impact. My name is Michael Tishivietsky. I live in Kells River. I have an extensive background in mining ventilation, which includes fans, airflow, heat, dust, gases, etc. The steel mill in Kells River was put under care and maintenance in 2010. It was sold in 2012. New owners took over. In October 17, the new owners restarted the plant. It had an immediate negative impact on the receiving environment, with 426 official log complaints in a short space of 2 years under the PAEL. I repeat that, 426 complaints. The major complaints were about noise, fugitive emissions, fallout, dust, fumes, smell, smoke, and explosions. We will be submitting a written submission as well to the Commission. Our written submission will explain the relevance between our case study and the need for environmental commissioner in the Western Cape. We'll start with the public participation process. The first public participation process took place around March 14. A comment and response document at this stage incorrectly identified an existing electric arc furnace, when later in 2014, the existing 36-ton electric arc furnace was entirely removed and replaced with a new, larger, around 45-ton unit. The reference to a 45-ton capacity is also under dispute, as we feel it may even have been larger. The comments by interested and affected parties were thorough. The valid concerns like heavy metal fallout, air pollution, noise, serious health impact concerns were raised. The AEL application process took around 9 months instead of the guideline 60 days from what we could see. There were clearly lots of internal conflict going on. It was not plain sailing. On the 2nd of February 15, the PAEL was granted by the city. An appeal process was lodged by the chairman of the Federalist Ratepayer Association in Kells River. The City Appeal Authority dismissed the appeal. There was a mayoral sit-down meeting with the then mayor, with community representatives, held in around May 15 to discuss the concerns. No minutes were available. In 2016, there was another round of public participation as the previous license period had elapsed. By this time, the community had lost both confidence and trust in the fairness of the process. Consideration should have been taken of the previous concerns raised in 14. In October 17, the plant started up. There was an immediate outcry from the surrounding community regarding excessive rampant air pollution, noise, explosions. Health complaints started: coughing, sneezing, wheezing, headaches, nosebleeds, insomnia, etc. On the 29th of January 18, a Ward 11 meeting was arranged by Councillor Fasaki. Mako was represented by Mr. Malusi Boy and Mr. JP Smith, who chaired the meeting. City officials for air quality and noise were in attendance. Spatial planning did not attend, but sent a written comment, which was loudly booed when read out. At this public meeting, I raised raised queries to the facilities general manager, asking what the actual plant design capacity was, as there were various conflicting reports in the media. These were later confirmed on the past and present company websites. The annexures will be submitted in the written submission. Something had changed inside the plant, resulting in the sudden, excessive, rampant, visible, fugitive emissions, extreme noise, explosions. I further questioned why the AEL made reference to 3 fume plants. To our knowledge, the bag houses use fabric-type filter bags, which only filter dust and do not capture fumes. The specialist engineer present admitted that fumes were not being filtered, so the fume plants did not exist. This was a shocking reference. Anyone from the community reading this AEL was placed under false pretenses right from the get-go, up front. It was grand misrepresentation, very misleading. How does this fit into our climate change action goals? We also verified by using Google historical images that the stack heights had changed significantly. In the air dispersion modeling done by the special engineer, he bases specialist reports on historical heights. That in itself is misleading. With my background, we started some community investigations. Due to the ongoing rampant fugitive pollution emissions, I decided to lift a few samples of dust from flat surfaces within the receiving community across the road for screening purposes, to be viewed under electron microscope. It's called microscanning. Elements such as iron, sulfur, copper, cobalt were detected. Based on these preliminary indicators, a fallout dust bucket project was initiated by the community. Dust samples were collected and sent away for full elemental analysis, and heavy metals were detected. This was all done at own cost, at own time. The results showed exceedances protective of a water resource for arsenic, cadmium, chromium, copper, manganese, nickel, and lead. Chromium, manganese, and lead also exceeded the standard residential soil screening values. This raised serious health concerns, as well as concerns about how this facility was potentially polluting our environment, the receiving environment, through the accumulation of toxic fallout. Heavy metals accumulate and do not degrade, remaining persistent in the environment. The Air Quality Officer sent our sample elemental analysis certificate to National Air Quality requesting guidance. I was also referred to the Contaminated Soils Act of 2010. In April 19, an oily mill-scale sludge incident was reported to us by a contracted recycling aggregate from the plant. We reported it to the Western Cape Deep for investigation. Section 28 report reveals further shocking exceedances of heavy metals protective of the water resource. Again, this will be in our written submission. In the PAEL dated June 18, the following comment is made by the city. A sample analysis of the baghouse dust obtained by the city indicates elevated levels of heavy metals, including zinc, lead, and manganese, which is cause for concern. No unit of measure was provided to define what elevated means. Compared to what? Lead is a priority pollutant of concern with its own standalone Lead Act, and lead is not even mentioned in the AEL. We then looked at the list activities, and we have some concerns about how this came about. The list activity should be identified as a process where mixtures of scrap, steel, and matter are heated and melted by the application of heat. The volumetric increase in the scrap feed into the larger electric arc furnace and its resultant increase in melting capacity is the source of most of the fugitive pollution emissions and increased noise. Around 95% of the pollution is generated during this process. At some point along the way, the melt shop electricity supply increased from 25 MVA to 42 MVA. That's approximately a 68% increase, which is significant. Indications where there's something had changed inside the melt shop. We believe that the abatement machinery remained largely the same capacity, no fume plants. The AEL shows that Cisco is listed for a list activity subcategory 4.7 and subcategory 4.2, which does not include pollutants such as heavy metals and certain fumes. We contend that the list activity of subcategory 4.21 for metal recovery should have been applicable, as this includes minimum emission limits for the sum of heavy metal pollutants and certain fumes known to be present at the facility. Had the AEL application included the list activity of 4.21 for the monitoring of heavy metals, would the facility have been allowed to operate in the general industrial 1 zone, when the city, in recent correspondences, continuously fails to recognize the facility as a noxious facility? Spatial planning does not bother to respond to this very query. The spatial planning issue seems to be another bone of contention. Residential development was allowed, houses were to encroach within 80 meters of the boundary wall. A technical report from the City Spatial Development Framework in 2012 clearly states that the facility had then become a nuisance industry and that the land use was not considered a complementary activity corridor use. It further noted that increased investment had been put into the steelworks to increase its production capacity within the past 5 years. Yet nobody is admitting that a plant design capacity increase had in fact taken place without the required EIA process. At the time of this technical report in 2012, this facility was closed. So who or how allowed it to reopen? The facility operates in a general industrial zone 1, a zone not appropriate for a noxious facility in such close proximity to a receiving community. The risk activity zoning classification fits clearly with the facility. The rezoning appears to never have been corrected. Even the air quality officer noted in the email to me, he couldn't agree more that the lack of a buffer zone is concerning, and that as far as he's concerned, he does not know how he is supposed to solve a land use planning disaster, which was not of their making, nor the companies for that matter. From the comment made by the air quality officer, it sounds like he also needed the assistance of an independent environmental commissioner. Many residents sold their houses and moved away from the mess. There's some historical plant capacities I'd like to just bring to your attention. The source goes back to the company's website, the history page. In 1967, they did 13,000 tons per annum of pool scrap. In 1973, it increased to 50,000 tons per annum of rebar, a different product. In 1982, 100,000 tons of billet, another different product. In 1989, 160,000 tons of billet. In 2012, 280,000 tons per annum of scrap steel. Other sources indicate that in 2013, the engineering news referred to a 230,000 tons per annum of rebar and to be further upgraded. In 2018, the IDC officially opening the plant and said that at full capacity, the plant would handle 500,000 tons per annum of scrap metal. In 2020, the IDC requested they called it a request for proposal, looking for a consultant. And in the document, they said the plant should handle 300,000 tons per annum of billet and to be ramped up to full capacity. There appears to have been 5 or 6 plant upgrades over 40 years. The community has not had sight of any EIA for this facility in spite of the many documented increases in plant capacity. Gradual urban creep was allowed by the city over many years. Where was municipal and local spatial planning oversight? To go back to the atmospheric emission license, as someone who knows, who has a knowledge of mining ventilation, I was able to look at the atmospheric emission license airflow calculations that the EEP, the environmental consultant, and the City of Cape Town Air Quality had all signed off. When I checked the calculations to compare the 3 stack exit point airflow quantities to their corresponding baghouse filter capacities, it highlighted that the airflow calculations were either hopelessly overstated or the baghouse design filtering capacities were hopelessly understated. A did not equal B for all 3 of them. The stack exit for number 1, the airflow was 235% overstated. Number 2, 216% overstated. Number 3, 144% overstated. Were the above stack exit flow calculations used for the in-stack monitoring process? I don't know. The above calculation concerns were relayed to the air quality officer, who requested an independent engineer's report to verify these measurements. The air dispersion modeling did not include any fugitive emissions or upset conditions, and at a stakeholder forum meeting, the consultant deemed them unquantifiable. This was the heart of our complaints. I repeat, they are unquantifiable fugitive emissions, unquantifiable. We don't understand how an AEL can be issued if fugitive emissions are simply ignored, not measured, not monitored. Suitable standards were not available to protect the receiving community and the environment from possible harmful, toxic fallout. We then went to PIRE. The PIRE process was a very bad experience. We are not lawyers in the community. I don't wish this on anybody. Suddenly, everyone somehow hides behind confidentiality. What's the point? Myself and one other requested access via PIRE to the engineer's airflow report and instack monitoring results and various other documentation. The instack monitoring reports were simply refused. I asked twice for them. What are they hiding? The airflow calculations report was initially refused. On appeal, I received a redacted copy of the applicable PAEL, which excluded these new calculations. Again, what are they hiding? If nothing's changed, what are they hiding? Previously, the facility proudly handed out the AEL. So why now hide the very same information from the community? What had changed? What had become suddenly confidential? If the airflow measurements and calculations are correct, and the instack monitoring is done to protect the receiving community and the environment, what is there to hide from? Please release the results. I also requested permission to witness the instack monitoring process, but my request was not entertained. Stakeholder forum transparency became meaningless. It appeared we were on a needs-to-know basis. A comment about the EEP. In an email dated 30 September 19, the air quality officer says the EEPs who assisted Cisco at the time were inexperienced in the AEL processes. My question, does this perhaps mean that the public participation process may have been misrepresented? Then why issue an AEL if uncertainty existed? Stakeholder forums. At one meeting, I requested to view the complaint register, only to be denied. I was told that there's some confidential information therein. All I wanted to do was see if one existed, quite frankly. On another occasion, I voiced my disapproval that meeting minutes were incorrect. At the last meeting in August 19, I tabled a presentation requesting clarity as to the plant design capacity and the EAF, actual design capacity. I questioned if the facility knowingly purchased the facility, which had an undocumented plant design capacity increase, which exceeded the AEL design capacity. The design capacity of the AEL is not on the atmospheric emission license. It does not appear. Nobody wants to tell us what the design capacity of this plant is. I also questioned the pollution source of heavy metals as found around the facility in community dust buckets and soil samples. This point was met with stunned silence. My presentation was acknowledged by the chairman, but went entirely unminuted. True story. I didn't exist. The final AEL following the provisional 2-year period appeared to be automatic and was approved about a month later. This in spite of 426 official logged complaints. I found the stakeholder forum to be a simple box-ticking exercise, generally insincere and an absolute waste of time. Who have we engaged with? The City Air Quality Officer, Information Officer, via PIRE, Spatial Planning, Water and Noise, and we still continue to engage. The Municipal Manager, AEL Appeal, and we've recently requested a full review of the AEL Award. We're still waiting for that reply. Community meetings with councillors, various MECs and mayors. We submitted around 30 affidavits relating to noise and health concerns, all of which went untested. The noise exceedance court case was thrown out of court in the Blue Downs Magistrates Court after about 4 years because of undue delays and a missing stenographer eventually. Why is this the community's problem? Western Cape deep air quality, pollution, chemicals, development planning, waste, we engage with all of them. We've met with local and national environmental management inspectors, the Green Scorpions, and we've had absolutely no feedback reports from either of them. We have attended formal meetings and presented at Western Cape Deep for the establishment of an IGTT, provincial and city, and it was dismissed, unanimously dismissed. We've asked for this decision to be revisited. We engaged with National Air Quality, National Waste Licensing, requesting guidance, SA Human Rights Council, the IDC requesting plant design capacity clarification. Remember, they put out a tender, so they gave us access to it. They opened the door. Based on a tender information that was in conflict with the plant capacities, as in the AEL. The IDC replied stating, regret, confidential. The Department of Labour, who only responded once. The public prosecutor from the Blue Down Magistrates Court organized an ad hoc public meeting to better understand the noise and health concerns. Minutes are available. Have we left anyone out? In conclusion, it should not be the public's responsibility to create non-profit companies for legal interaction, to have to interact with social justice and environmental organizations, read copious amounts of legislation and try to understand them, and then to try and argue them, to research, investigate, and pay for scientific monitoring of pollutants, send emails and attend meetings, learn about electric arc furnaces and related pollutants, correct sums of specialist engineers, take hundreds of photographs, video recordings of fugitive emissions in the background, which continued until the day the facility closed, somewhere around September 17. Sorry, 19, sorry, apologies, 19. Office bearers are well equipped in NEMA, whereas the community is not. Is the community expected to become experts in environmental law? Wow. Any receiving environment should not be expected to be impacted so negatively. The public needs to be able to have confidence and trust in administration and procedural fairness. In Kuils River, these systems failed us dismally. Pollution doesn't lie. Thank you.
Mr. Michael, do I understand that your entire submission is jointly with you, Ms. Lee?
Yeah, I did.
Okay.
Yes, yeah.
That is duly noted. Thank you so much. As I've stated in the beginning, in terms of our mandate to maintain oversight, it is there in order for the legislative process to be open, fair, and transparent. So thank you for your input. It is highly appreciated. I trust that the department have made note, and if you wish to at a later stage after the input want to make any comment, you are free to do so. I will now note Mr. Mark Wiley.
Chair, just before, is it possible that we can get a copy of that presentation now, like even a hard or soft copy that the gentleman has just delivered, so that if we want to ask anything, it'd be useful to have the document with us. I'm sure we can make copies if
I'm sure we are able to do so. Our procedural officer will collect the document and then provide a copy to members of the committee. Thank you so much. Members, I will now note Mr. Mark Wiley.
Thank you, Chairperson. My contribution is slightly more overview and in principle, although I found the previous speaker's input to be absolutely fascinating. To have fire, 3 elements are required: heat, material to burn, and oxygen. Take one of these away and the fire dies. Similarly, all life also works on 3 elements for survival: the natural environment, the built environment, and the living environment. I'm very pleased that the department is here represented as the Department of Environment and also Development Planning. So you see the matter holistically as well. Take one of these elements away and you will cease, and life will cease to exist. It is unfortunate that when talking about the environment, some people choose to be selective and refer to only one or the other element and choose not to see the whole topic as interdependent. What affects one element will ultimately impact on the other. Thankfully, in recent years, the neglect of and devastation of the natural environment has now got to the attention of world leaders, and significant political weight is now being channeled into measures to mitigate the effects of climate change, global warming, and the reckless stripping and despoliation of natural resources. In fact, other than the Olympics, nothing has brought more countries together to pledge support to in essence, to save humanity as the climate crisis and allied threats to the environment. The threat crosses all borders and nationalistic divides and trumps any constitution that we might have. So why is the Western Cape government choosing this time to give the impression that it wants to distance itself from the debate? It has a lot to lose as a result, and the least of which is public opinion. The post of the Commissioner for the Environment has not been filled by successive provincial governments representing 3 different political parties for some 24 years, which in itself is tragic and remiss. Many in the executive office see the post as a threat. It should not be so. My contribution here today is to try and convince the doubters that not only that this post needs to be filled, but it can be to the province's advantage to do so. This province can already pride itself on being a good example of a well-run regional government, on par with the best anywhere. This fact is borne out by the empirical studies, audit reports, evaluation reports, and investor confidence. Quality delivery of basic municipal services, as well as high levels in education and health, are well documented. It does not hurt that we are also located in one of the most beautiful and biodiverse parts of the world, and have a long and established economic base that includes agriculture and manufacturing. We are therefore the envy of many. But it has significant threats, and no amount of investor-led development is going to avoid a potential catastrophe. When we passed the Western Cape Constitution in 1997, I was just across the way at the other house at the time, it not only fulfilled an opportunity afforded by the National Constitution to develop its own provincial identity, but also reflected the reality within the Western Cape at the time. Let me explain. As stipulated in the Constitution, this legislature has 42 members. This calculation, as it was done in all the other 8 provinces, was based on 1 seat per 100,000 population. In other words, the Western Cape had a population at that time of 4.2 million residents. As of today, according to Statistics South Africa, the Western Cape has a population of nearly 7 million, a massive increase. How is this possible, given the birth rate within the province being within the national norms, in fact, below the national norms? The truth lies in that the success of governance in the Western Cape has also become its greatest liability. Others, not just from within the Republic, but also further afield, want a better life, quite understandably, and travel south in numbers to get it. Our nearest neighbor, the Eastern Cape, had a population of 6.3 million in 1997 at the time of the Constitution. It now has, according to Stats SA, a population of 6.5 million, a mere increase of only 200,000 in 24 years. These artificial population shifts, in most cases as a result of the collapse of their built and living environments, have had a serious effect on the provincial and local governments of the Western Cape and their ability to continue to provide quality services. These serious increases in population are not planned and are unfunded. It must be noted that the budget share of the Eastern Cape this year remains at a constant upward trend of 83 billion rand, while the Western Cape received 72 billion rand, despite a bigger and increasing population. The effects on the holistic environment is staggering and cannot be sustained in the future. Annual school enrollments see an excess of 22,000 previously unregistered learners clamoring to get into the schools in the Western Cape, and housing backlog is well over 600,000 and getting more by the day. Speaking of correction, but I think the enrollment of previously unregistered people in this province for this year was 29,000. Informal settlements mushroom and spread in every town and suburb, invariably occur in wetlands and reserves. In researching for this presentation, I read the City of Cape Town State of the Environment report of 2018, which I think is their last one, as well as the province's environmental outlook, also dated 2018. I wonder how many members of this legislature have read these documents. Both are well-researched and comprehensive documents that should be required reading for every public representative. I suspect much of the political rhetoric and simplistic posturing arguments may fade once the reality sinks in. As professional and diverse as these reports may be, the City of Cape Town, by the way, produced something like 1,008 environmentally based reports in the last 15 years, integrated planning documents and things of that nature. They also identify increasing threats across the environmental spectrum. It is quite apparent that existing laws and the enforcement thereof are not working, and we've heard an example, a case study example now, as they should. Greater focus and more energy is urgently needed. For example, in the Provincial Outlook report, virtually every topic that is listed has an outlook in decline, in other words, in deteriorating circumstance. Those topics cover land, human settlements, biodiversity, ecosystems, inland water, oceans, and coasts, to name a few. The report predicts a population increase to 8.1 million by 2040. You will clearly be able to figure out for yourself that this is a serious underestimation based on the current population growth of this province. Furthermore, under the chapter Emerging Issues, the following are some of the issues looming large: ongoing effects of climate change, increased renewable energy developments, shale gas prospecting, increase in sand mining, shortage of landfill space, and declining pollinator population. For those who are not sure what that last one is, that is the die-off of bees for pollination, upon which most of the food that we eat is dependent. Each one of these matters has significant challenges and a few opportunities for some. They need to be monitored closely. So how would an environmental commissioner help in this terrain? Firstly, by being independent and an authority on the topic, he or she would give feedback with a level of credibility and gravitas that is so lacking in politics today, rightly or wrongly. Politicians, and by extension their officials, are all too frequently seen as biased, corrupt, and having ulterior motives. Regrettably and unfairly, this is a sign of the times worldwide, and this distrust is constantly being fed by unfiltered social media comment. None of this is healthy and essentially undermines the very constitutional systems we all agreed to. So what would the role of the Ombudsman in this regard be? Chief Justice Rumpf put it as follows in 1982. In my experience, has taught me that a great need exists for a neutral, authoritative person to which the ordinary citizen can apply if they are of the opinion that they are of the opinion that they have been done an injustice. Experience has shown that, in another quotation, the majority of cases were ill-founded, based not on fact or in law, with the result that the Ombud protects the administration from the public far more than he protects the public from the administration. That is a quotation from Mr. H. Rudolph, the Ombud and South Africa in 1983. But given the unique and urgent times we are experiencing, it is in other areas that the Commissioner can be of invaluable assistance. Firstly, the report backs will have to be done to the legislature, which cuts across the narrow and limited departmental briefings to small committees. And I mean, this is an example of a small committee. This topic needs wide audience given its importance. Secondly, by liaising with and engaging with a wide spectrum of government spheres and departments, the Commissioner will be able to give a broad overview and advise the executive where gaps exist and where policy can be improved. A Commissioner backed and empowered by dedicated legislation will have a better chance of discovering documents and information than existing routes at this province's disposal. For example, the Table Mountain National Park, although created under another name at the time, was proclaimed by President Mandela in 1998. This followed intensive discussions and negotiations with various departments, both the province and the city and landowners, for the consolidation of land to form the park. At the invitation of Minister Meyering, the Provincial Minister for the Environment at the time, I attended the initial discussions with the National Park Executive and the Chief Scientist, Dr. Hall Martin. What was agreed there and later encapsulated in a clearly written heads of agreement with Sandparks is not what is in place today. In its place has become decades of increasing abuse of the public trust by the Table Mountain National Park management, dishonesty, lack of transparency, lack of accountability to this legislature and the city, and to representatives who pledged its land to the custodianship of Sandparks for the benefit of the citizens. Attempts over the years, including by committees of this legislature, to get answers were met with avoidance and stonewalling. The city is not innocent in this matter, as it failed to ensure that the Table Mountain National Park has maintained an open and transparent relationship with the council, disclosed information like finances and tariff structures, and ensured that bodies like the Park Forum are functional. Remember, we have a vested interest in this park. No annual report is forthcoming to the general public, and even responsible national minister has given vague half-truths by the park when pressed for answers by national parliamentary questions. What we do know is that the Table Mountain National Park made 307 million rand in the 2019-20 year and admitted only to expenses of a third of that. The balance went to the national head office despite staff shortages at Table Mountain National Park, poor land and biodiversity management, which we saw in the result of the fire recently that took out the Jagger Library, and declining security levels that have put the surrounding residents and park users at risk. The Commissioner would report on this long-standing issue and make recommendations. To date, virtually all actions taken to hold the National Park accountable have come from civic action groups, like the gentleman indicated already, who have raised millions to defend their rights in courts and elsewhere. Similarly, the Provincial Outlook Report of 2018 quite correctly refers to the marine environment matters, but fails to make specific recommendations on this critical topic, which has long and specific import for the citizens of the Western Cape. In excess of 80% of the fisheries product of South Africa is caught off the coast of the Western and harvested off the coast of the Western Cape. To this end, previous administrations, provincial administrations, developed 12 small boat harbors, other jetties and quays along the coastline so that the local subsistent fishers and their communities could get to the sea and return safely. Through gross mismanagement of the resource and corruption, we see today whole communities reduced to impoverishment and in some cases to organized crime to survive. These activities have a massive knock-on effect throughout the province and is reflected in spiraling crime statistics. It is well documented that there is a direct correlation between poverty, through the denial of legitimate access to local resources and crime. A commissioner would be able to obtain certain relevant information and recommend courses of action. There will be some argument that the examples I've chosen to give relate to national competencies, and provinces have no sway there. However, it can be shown that through gross mismanagement and corruption, that the citizens of this province have been severely disadvantaged, and I believe that no court will in fact side with the perpetrator. This legislature has a proud history of challenging any person and or sphere of government in its pursuit of the truth and to the benefit of its residents. Examples of this were the Toyota panel van conversion hearings, where even the national deputy minister appeared, the national head of transport who was summoned, the head of the SABS, the NCRS, banking intelligence committees, the head of Toyota South Africa, all of whom sat in the middle over there in the cross benches and under sworn testimony gave evidence. Similarly, other hearings were held relating to the visa debacle, where the national minister was shown not to know the difference between a passenger liner and a cargo ship, the Parliament poaching related matters, and sitting where that gentleman is over there, the National Commissioner of Police appeared in front of the relevant standing committee for the first time a national commissioner has appeared in front of a provincial legislature. The National Constitution provides for special delegations of powers to provinces. For that, the province would have to have a strong case based on facts. It has also been claimed that more recent legislation has overtaken events and the post of the Environmental Commissioner is therefore redundant. If that was the case, why are there so many cases going to court led by civic groupings and individuals who feel that their rights are being infringed? One aspect I missed in all the environmental reports, in fact, most annual reports, was a report back on how many environmentally based cases or appeals have been lodged by civil society against departments or vice versa, or alternatively by departments against another sphere of government because the Intergovernmental Relations Act has failed in their negotiations. How many intergovernmental disputes have been lodged, and what is the status of these disputes? Surely this information would be critical to understanding the efficacy of existing law. Nowhere do we get this information. Let's not, and it was mentioned that there are the forums like MINMEX and other executive level bodies. Fact of the matter is, because I was one myself, these are negotiations with national ministers often, and you can't take necessarily a hard line on a particular topic because you need to have their cooperation and their support for other issues. Therefore, you don't take a legalistic line in the way like a pronouncement of a court. Let's not forget that this province created a much needed police ombudsman, which has already been alluded to in the presentation by the attorney, into provincial law precisely because the existing IPID law left so many gaps in areas that affected citizens the most, service delivery related matters. The information being gathered via this edition and the actions stemming therefrom have justified its existence and its expense. Lastly, as far as the cost is concerned, if only a fraction of the revenue that the FFC, which is the Financial and Fiscal Commission, should be sending to this province based on legitimate claims, and if Sandparks returned a portion of the profits, then the cost of the commissioner would be justified beyond measure. Mr. Chairman, although I think an amended form of the environmental commissioner can be debated and has merit, given the time lapse since its inception 24 years ago, I seriously think that to remove it completely would be sending completely the wrong message at this time. Thank you.
Mr. Wiley, thank you so much for your input. Members of the public, those that are online and those in the chamber, we are doing well for time. Our public hearing is set until 6 o'clock. We are going to continue at this moment, and I will note Mr. Frank Raymond.
Thank you, Chairperson. I've been here, and I welcome my presentation. It's very nice to hear that. I really enjoyed what he's saying. Also, I see before a lot of courses, I was the official of the state attorney. It is some wonderful work. I hope he's still doing the wonderful work, and I hope Paul will fight the flag of the Environment Commission, because he's a greenie, and he's a hardcore greenie, I hope. So, Chairperson, I'm a lawyer, and I act for the concerned Federalist today. That's my client, and Rian Smith is sitting next to me. He's a chairperson. So let me just placate all fears. We're not a political party, or the Concerned Federalist is not a political party, but a NGO looking at constitutional developments. And as you know, there is a not to use the G word, what people use, what they think of governments, but there is a problem about governments as a whole. We feel that there's a centralist approach. I'm going to give you a background of federalism where we stand. A centralist approach from government. So we are a federalist state with 9 provinces. So federalism has gone away. Professor Peter Hock, who is the guru of environment, or in fact, the guru of constitutional law, if you Google him in Canada, I would say that we are a pure federalist state. We are the basis for our state is we use the principles of Canadian Constitution, the German Constitution, and the Indian Constitution. They're all federalist states. So, but now there's a huge erosion of federalism, a huge erosion. To start with, we had constitutional principles in the 1993 Constitution saying, checks and balances. There's 3 tiers of the different separation of powers, as Montesquieu has said. Separation of powers, and we started greatly with this. And the Western Cape government started with a provincial constitution. KwaZulu-Natal also had one, and later abandoned it. So we have one provincial constitution in all other provinces. Now that's shocking, really, because provincial constitutions would give the provinces power. Our ministers are called provincial ministers, although in legislation you call them MECs. Yes, they're MECs. So the national government don't recognize the provincial constitution, seems to be. But be it as it may, for instance, Ma'am Helen Ziller couldn't call a commission of inquiry because of the Khayelitsha problems that we have in the police stations if it wasn't for this constitution. You couldn't have taxes for doing that. And as you're well aware of, there's 2 entities were created. One was a Children's Commission. Now, the Children's Commissioner is not a core function of his parliament, provincial parliament. Children is a national thing. It's about, well, so it's argued. But now you've brought children, the rights of children, in criminal procedure, whatever ways, into your parliament. Now, before I get let me just say, I omitted to say, this parliament should be enlarged. I mean, it's ridiculous to have 42 people, parliamentarians. I don't know how they do it. You have, I think, the Oeverstand municipalities got about more councillors than you have in parliament. I think it's shocking, and I hope that the parties work together to enlarge the parliament, because the more people there is, the more service delivery we'll get, and the more we can go to our members of parliament and complain. So that's the one thing. But the removal of the Environment Commissioner would be disaster from the Concerned Federalist point of view, but also from an environmental point of view. And I'll point out to you the fallacy of the argument to say that all of a sudden that the National Environmental Management Act, that promulgation caused this whole thing to fizzle out. I'll show you. There is no substance for that. And I'm going to make. And I had to dust off an old book, Environmental Management by Fugel and Rabi. Remember Professor Fugel and Rabi? I had to dust it off. I don't think you can't buy it anymore. It's an old book, but I'm going to get to that now. Why is the Western Cape? Why do people come to the Western Cape? Not because of mines and of buildings or whatever. It comes because of the unique fauna and flora that we have. Mr. Hardcastle will tell you that, and I see on the emblem, is that a diamond or is that a protea? Is that a Cyanorodus over there, Paul?
Koi pot.
Is that a koi pot?
Yep.
Oh.
And grapes.
Oh, so they took the protea away. That's a pity.
Proteas in the top of the crown.
Oh, okay. But be this as may, you are home to the unique fynbos, which is internationally acclaimed. They are historic. In fact, they are living fossils. They are 300 years old. They come from Gondwana land before the continents moved. That's why you find fynbos in Australia, New Zealand, and you find restias in South America. And it's the southern Gondwana land. That was where the plants come from. And people don't come here to see Las Vegas. They don't want to come here. They want to see the unique fauna and flora of this. And one of the directive principles of governments also refer to that. But I hope you've read. Two reports. One is a Greenland report, which was in fact Bro Greenland, who was the director of in the United Nations. And after her report, the Biodiversity Convention was in fact established. And I'll get back to this sustainability principle that was in fact formulated, which forms the basis of environmental conservation or management. But Douglas Hay is also a book that I think I bought from one of the staff members from. This was a book that was done by a wonderful man, Dr. Douglas Hay. He was one of the founder fathers of environmental conservation in this province. And in fact, the money that was copied was 1995, and all the money that was in fact gotten from this book went to nature conservation. But I wanted to refer you to what he said in conservation regarding two things. One is money. I'll read you just one paragraph of page 202 of that specific book. He says, the importance of inadequate funding to conserve the national asset cannot be overemphasized. Unfortunately, nature conservation has always been the bottom of the totem pole as far as allocation of funds is concerned. Environment Commission, the same thing, and will remain so until the importance of nature and environmental conservation for the future well-being of all South Africans is fully appreciated and recognized. So, environmental education. Conservation is not a first world luxury. Let me just read that. Conservation is not a first world luxury, but an essential for the survival of mankind in the long term. All the bees are just, if all the bees die tomorrow, Western Cape would die with it. So, if you want to know about biodiversity, it's a net. It's a net. It's interrelated. You take one web away, the whole thing falls apart. So, just to carry on with what Dr. Hay is saying, the provision of funds for the management of nature reserve, nature areas should be shared responsibility of the state, provinces, and local authorities and the general public. Nature conservation can never be self-supporting, and while the general public will have to make a far greater contribution to conservation in the future, does not exempt the state and local authorities from their responsibility towards our fauna and flora, national parks, and nature reserves. And in his slotstorm, the last page, they call it Quo Vadimus, the last paragraph, he says, I'm not going to read it to you, but he says, this was in 1995. When he was a young man, this was the province of lush environmental richness and resources. It's overpolluted. The wildlife was plentiful, and the flowers that was gone, the habitat is gone. And when you destroy the habitat, he says, we're on a slippery slope, 95. Now, what did the framers of our Constitution had in mind in 1995? In 1995, also a young lighty, and I also appeared before the commission. It was chaired by Henny Bester, I believe. And I acted I was there on behalf of the Royals Ratepayer Association saying, please protect the unique fauna and flora. And there was a lot of presentations that I can remember was also there, unique fauna and flora. So I would have thought that if our founding fathers of this constitution had in mind to protect the unique fauna and flora, and they created, and also there was in this presentation I also heard there was issues about children that we still have, and I believe Mr. Mark Wiley was one of the people who he suggested, I believe, that we have within the committee, and that we have this. Apologies, Mark, if I say that, but the founding fathers had the guidance of people like Dr. Hay, like Dr. Hay, and of presentations that I had. Now you're telling us, no. So I was quite shocked to read. Let me just get that information brochure. It says the DETP position is as follows. It's undesirable. How could that commission be undesirable? Okay, firstly, for duplication. Secondly, there's scarce resources. There will always be scarce resources. There's always scarce. There was never enough money from when the Constitution was proclaimed, and the Constitution was proclaimed in 1997. I think it's Act 1 of 1998 was certified by the Constitution as being correct. Was certified saying that all those mechanisms are certified as being consistent with the constitutional principles. And if you take that back, we will see you in a constitutional court to oppose that, and that's a guarantee from our side. If this is going to be removed, we will take action about that. But be advised that the last one is the removal will not address governmental gaps. Then the argument was that, the Conservation Act of 1990, 73 of 1998, apologies, in fact, fizzled out because NEMA took everything over. No, that's not correct. This Environment Conservation Act was more conservative and had more powers to government than NEMA to some extent. There's one gap, and it was NEMA as a referral to mediation, and that's not in this law. But I'm going to take you through the specific. Before I also go there, the Environmental Ombudsman is not just a unique thing from the Western Cape. It's also in Canada, it's in India, and it's also in Australia. And that'd be a huge compliment. And to get to the money point of view of that, you don't need 13 million or 10 million or whatever. You can get a retired judge with a secretary and one staff member. Get a retired magistrate to do that. You can get a retired professor, academic, Jan Dzeski from UCT, Penny Mustard. You can get people who would be willing to do that work for much, much. You can negotiate with them. It's for these people is not about a salary. It's not just about a position. But our Constitution, Western Cape Constitution specifically says, and I read you, the Constitution confers on this Environment Commissioner. It says, well, firstly, there shall be one, or there is one. We know there is not one for 24 years. He's independent, and he's subject only to the national constitution, this constitution, and the law. It's impartial, must exercise powers and perform functions of the office of the commissioner without fear, favor, and prejudice. Now, he will not be. I'll tell you what he will not be being chairperson. He will not be an official who would bow to pressure. He will not be that. He would say, the environment I'm here to make certain that people will get justice, environmental justice, as one of the principles of NEMA. Now, that person, nobody can interfere with him, and he reports to Parliament. So it's objective. He's not protecting a political party. He goes there, and Parliament appoints this person, and to say, and he would give a report, he or she would give a report from time to time, and if there's a problem, then you complain, then you make this investigation. Now, what is, as Mr. Wadi has pointed out, you have a police ombudsman created by the government. Now, police, that's, you would say, but that why do you do that? We've got IPID. There's staff, there's colonels, there's generals on IPID. Why would you do a police one? It's a good reason for that. What I've established. There's nothing wrong in the same principle to appoint the Environment Commission. Now, I have to take you through the difference between of the Environment Conservation Act. The Environment Conservation Act had also various policies, and the policy, general policy of this act, there was a general policy, there was a general policy on control of vehicles, and there was general policy also on terrestrial and marine protected areas. But it was a strong policy. It says every person, every state, every legal entity has a responsibility, must do this. And if you can, I'm not going to read this to you, but this is one of the strongest policies, environmental policies ever created up until now. It's even much better than we have a National Environmental Management Act. We have environmental principles. We must empower women. Yes, it is so. This province says we have to look at environmental justice. Yes, same thing here. We have to look at things like the environment's held in public trust. Yes, the same thing. But the Environment Conservation Act goes further. It established a environmental council. So you had if I can just find that. Well, this is it. The ECA also utilized cooperative government decision making, environmental policy. There was a Council for Environment created. Council for Environment was specialist advising the National Minister, which was brilliant. I don't know what's the current. And then there was also a committee of the environment management, which advised specialists advising the DG. Then you had animal called limited development areas, where there's pristine development that's taken out. You had special nature reserves and protected areas. You had appeals to the minister. The minister could appoint a board of investigation, right? So a board of investigation, you would write to the minister and you say, well, yes, environmental issue. The minister would get a judge to appoint an inquiry. This happened in the Van Heijten case. Van Heijten with an issue about the development in Langebaan in 1995. It's a reported case. There was a financial address. So if some decision of government, this is in the Act, if there was a decision from government that adversely affected you, you could have a financial address. That's not a NEMA. There was criminal and civil penalties. There was issues regarding Section 35A, for instance, that empowers the ministers to if an opinion of the minister, a competent authority, local authority of government institution concerned, any person performs any activity or fails to perform activity, the minister can give a notice, and that's a form of interdicted. There was also regulations regarding development of areas, regulation regarding environmental impact reports, regulation regarding noise, shock, vibration and shock, and how these procedures would deal. Regulations regarding littering, regulations regarding waste management. So I challenge anybody who would say that this ECA was just a junk piece of legislation. It's far better. It's far more impact than NEMA. That's my submission, and we can do that to court if necessary. And now, so your argument regarding it's got no legal substance is totally wrong. Just on a point, can you imagine when the WSSD, the World Sustainable Development Forum in 2002 occurred, Greenpeace decided to go and sit on a dome, Coburg, remember that? 2002. Now, an environment commissioner could have had an inquiry about that. Summons the relevant officials, say, well, there's clearly serious concern about your policing of this key asset. I mean, surely they only were found when they're on the dome of Kuba, our nuclear station. So regarding federalism, the independent ombudsman can summons by way of subpoena people to persons, organizations to say, bring me the information. Tell me, Mr. Director General, come and see me. We want to work together. Cooperative governance. Environment is not a little block that you have. This is environment. And that we do. Now, what you're trying to do, what this bill's trying to do, is to separate the environment. You separate the environment, you separate the people from the environment, and you're telling us it does not matter. Environmental commissioner could have will report to Parliament, will report to the department, and will deal with environment as it stands. So coming back to from the part of it, the Brinton report, the environmental management basically based on the definition of sustainable development, and environment was economic growth that we must do, environmental protection, and social equality. So those are the principles the Environment Commissioner must enforce if that's not done. Now, the argument was when this law, Act 1 of 1998, apologies, Constitution, was promulgated. If you look at, it says here, Afrikaans text signed by Premier assented to the 15 January 1998. So 1998, let me tell you what happened in 1998. In 1996, the green paper for NEMA came out. 1996. The white paper of NEMA came out in middle, I Googled it, it just says, Google tells me it's middle of 1997. So when the white paper came out, it was a blueprint for NEMA. So why would the framers of the Constitution go to the Constitutional Court and say we want Environmental Commissioner, knowing that there's already an act incoming? So it's a flawed argument. It's after the fact argument that you're saying now, but there's no laws that existed. That argument does not going to hold in any court. So then I wanted to, we said Environment Commissioner doesn't have to be a jet pilot. It must be independent. There must know some knowledge. You don't have to pay that much. And we are, from Federalist point of view, saying that yes, well then we can have oversight. Then this government can have oversight over other things, sand mining, sea resources, EBITDA. You can say, well, everything that happens, as I say, the web of life, you torring aan een draadjie, dan val die hele ding in mekaar in. So nuclear energy, sand parks, the Environment Commissioner had the power to do that. And it was envisaged that Environment Commissioner can do that. It was certified by the Constitutional Court. The Constitutional Court. I was there as an attorney for KwaZulu-Natal, but it was thrown out because it didn't adhere to the principles. KwaZulu-Natal wanted to succeed. It was a level afstig at that stage, if there were some problems. So, Chairperson, if I can just go through my notes. As to what was said, Mr. Wadi referred to Judge Rumpf. There was few environmental green judges. He was one of them. Other one was Judge Albie Sachs, who said in the Futile case, saying, I want more environmental stuff to come to Constitutional Court. So maybe there's an opportunity that we can deal with it. So environmental matters really goes to the Constitutional Court. Mr. Wadi also referred to NGOs that must take up the sword. That's absolutely correct. Absolutely. If it was not for NGOs, then there would have been disastrous legacies left. Wasn't for them. Wildlife Society. There was an NGO at Koster. Koster was a little, little municipality in the middle of the Free State. NGO go to court and say, well, my municipality can't deal with waste management. Well, you deal with it. So please don't pass off your duties to NGOs to deal with. Chairperson, I'm nearly finished. I just want to take instructions next door because I missed probably a couple of things. Just to end off, we want more powers for Western Cape, not less. And as part of federalism, federalism is devolution of power, not centralizing the power. So again, it's more powers to provinces and more powers to municipalities. So decision making must be close as possible to the people, and the people must be able to access a provincial parliament, and their access would be to go to a neutral person. They align to a different political party or whatever. They would go to a neutral person. So I have a problem, assist me, and you'll be assisted. So please, I want to ask the chairperson official to rethink this, to enlarge this parliament, that it should be, but not to scrap the Environment Commission. Thank you.
Thank you so much, Mr. Frank Watson.
Raymond.
Raymond, so sorry. It's that afternoon. You mentioned you don't know how we do it, that's what you members. I myself don't know how we do it. It's being worked out, but we have a number of indicated FPLs that is working together. Hence, we are taking this oversight in this public hearing process in order to see how can we obtain this manual from members of the public. So it is initiated to those that are online and listening. We have noted that I have purposefully not added a time allocation for people because we want the members of the public to meaningfully participate and to provide to us as members. Online to do this is Mr. Ali Diabasa. Are you still with us, Mr. Ali?
Yes, Chairperson.
At this time, I was requesting that you put on your video.
Or do you want to stream on my video?
And I will now hand over directly to you for your verbal submission. It's good.
Am I audible?
Can you take your earphones out? You might be able to hear better.
I don't know, Chairperson, can you hear me?
We can hear you now, sir.
Okay, thank you, Chairperson. Chairperson, good afternoon to members and the public. I'm going to canvass 2 points, Chairperson. The first one will be the commissioner, section 71. The second one will be the money bill. Now, I'm looking, Chairperson, at the decision, the basis or the reasons that are advanced by the department to conclude that the position is no longer desirable. Duplication is going to consume scarce resources and it will not address the governance gaps. Now, Chairperson, let me say that those decisions, Chairperson, I'm still saying, I said it in Mosul Bay, they are flawed. I'm going to advance my argument why I'm saying they are flawed. I'm going to give examples of this. Now, can you still hear me, Chairperson?
We can hear you, Mr. Diabasa.
Okay. I think I'm going to introduce, Chairperson, the test of desirability. The first test is that our Western Cape government, has to ask the question as to what was the intended establishment of the Environmental Commission. What was that intention when it was established and was part of the Constitution? And I guess that intention was to the benefit of the citizens of the Western Cape. That's the first question that has to be posed. That question should be, is that public benefit of the citizens of the Western Cape no longer desirable? That's the first one. The second one, the second test is the test that says the office as it is now, as it is outlined in the Constitution, with government not having activated it, is the intention now defeating what the Constitution provides? Has government developed a reason not to activate this office of the Environmental Commissioner to suit the narrative? Because the presentation of the official says that decision has to be political or has to be a policy consideration decision. So the second test must be the test whether terminating or repealing Section 71, will it adversely, or negatively affect the citizens? The third test, based on the two, the government has to ask themselves, what if we have activated this office, and then maybe after a year or 3 years we come to a decision and say this is no longer desirable as it is a duplication or wastage of scarce resources. But Chairperson, government cannot say that because the office was never activated. They cannot say that. Number two, government can never say that because what we hear now are the reason not to activate the office. Now, I want to give an example here in front of me. I've got an example of environmental authorization. Now, I just want to deal with the aspect of public participation. Now, I read this and I've zoomed into the approval in as far as public participation is concerned. Then I'm reading here, it says that in our opinion, public participation has been, the minimum requirements of public participation has been complied with. And it says that the reason we can see that there was notices were issued and were distributed to interested and affected parties. It says that a notice was placed at the entrance of public facilities. It says there was an advert in the paper. It says the copies of the scoping report were issued and were placed for 30 days for public comment, and the hard copy was available, and all of that. So, Chairperson, but if you look, Chairperson, at the definition of public participation, you will see that that definition, I get it from section 2(4)(f), of the Act and 0 of the Act. It says the participation of intended and affected parties in environmental governance must be promoted, and all people must have the opportunity to develop the understanding, skills, and capacity necessary to achieve equitable and effective participation. So my argument says the kind of public participation that is there now does not benefit the public. It's just a big box exercise. It is not meaningful. Our people are not capacitated, do not have the skills to understand this that is being that they are being consulted on. Number one, they are not equipped with the development or with the project, under review, and the people that are vulnerable, that will be adversely affected by this, are not even consulted. They are not even part of this. Now, if I go to that, back to the conditions of approval, it will give people an opportunity to appeal. But when people appeal, it will say to them, they must appeal 30 days, 30 days after the decision has been made. And that process of appeal is cumbersome. The ordinary people do not have the skill and understanding of appeal of that process. So what I'm advancing is that the public, citizens of the Western Cape are not protected, the environment is not protected, our biodiversity is in danger. What we are seeing here is an advancement of profit, and development that do not benefit the public. I just give you a few examples. I'm from Mossel Bay. There was a public participation here in Mossel Bay of a point resort that was privatized. People participated in that. I participated in that. We've made written submission. Despite all of that, there was no response. The resort was privatized. The second one, Dibake resort in Mossel Bay. A public access beach was privatized. There are boom gates there. People are no longer freely able to access that resort. There was no public participation at all in that. The other one is the famous gas beach, where there was no public participation at all. So what I'm saying is that despite the voluminous or the lots of legislation in place, but they do not benefit the public. They do not protect the public. Now, I think government must go back. You must look at the powers and functions of this environmental commission. If the determination is that they are weak and lapdog, review that, strengthen that, give it powers and functions, so that our people can be protected. So the argument to say that it's a duplication, it's not a duplication because we're not protected now. We need protection. Number two, it's a waste of resources. It's not a waste of resources. You must make it efficient, and effective. The third one is that there are no governance gaps. There are a lot of governance gaps. Hence, we're complaining now. So I won't belabor, I won't canvass this issue further because the other guys before me have canvassed that one. Chairperson, let me go to the last one. Am I still audible, Chairperson? Chairperson? Yes, Chairperson. I want to go to the money bill, Chairperson. Section 30, subsection 2(3) of the money bill. Are you with me, Chairperson?
We can hear you, sir.
Okay. That clause, it says a provincial act which must provide for a procedure by which provincial parliament may amend the money bill. Now, my submission is as follows. We are in a democracy. We are not in domination. We are not in domination of a party by another party. But we are in a political system where the will of the people must be respected and enforced. We vote for members of the provincial legislature. They go into provincial parliament with a certain permutation, party A 30%, party B 40%, and so forth. Now, that clause I asked in Mossel Bay, whether when there was public participation, is there an enabling legislation or a procedure by which to amend the money bill? I got an answer that no, we don't have that. I want to urge the Chairperson that we need that. You see, when you amend the money bill or approve budget, it must not be the issue of vote. You just vote, the majority wins. That's not democracy. Not at all. Democracy, it means if party A has 20% popular vote in the Western Cape, at least 30%, of money in that budget, must be able to advance the will of the 20%. 30% must be able to advance the will of the 30% of party B and party C and so forth. You see, because that principle then disciplines political parties, it enforces them to consult each other and begin to trade off, and reach a compromise. So what I'm saying is that I think we need to activate that. We need to activate that. There's gap in the provincial constitution. We're not doing this. Let's not repeal it. But I'm moving that we must activate. We must have a procedure and an enabling legislation to activate this. So those are my submissions, Chairperson. Thank you.
Mr. Diabaza, it's always good seeing you, sir. Thank you so much for your input. Thank you so much. Members of the committee, the department, as well as members of the public, thank you so much for the valuable input. Mr. Diabaza, I can state on the record that the committee also resolved in order to extend our public participation process in that regard, and we would surely call on each and every person of the public to keep on encouraging other members of the public to also take up their role as active citizens. I trust that the committee will feel satisfied at this time that we have, from our side, facilitated public participation processes in order to obtain public input. We are in an extremely difficult time in the COVID-19 new normal, what it's deemed as a new normal, but we will continue to strive for that, where more and more citizens are engaged, where we have an active citizenry, regardless of the age, where young and old are able to come together in order to meaningful participate in this regard. So to each and every member that participated, members of the public, it is highly, highly appreciated. I would now at this stage wish to, we are doing well for time, members. We are, before I note Member Dugmore, we will do our resolutions directly after we have concluded here, and there is refreshments available for the department and members of the public. But before I take your hand, I just want to double check from the departments. Is there any comment from you at this stage?
Nothing from my side. Thank you, Acting Chairperson.
Nothing from the department side as well.
Thank you. Member Dugmore, I see your hand.
No, thank you very much, Chair. Just through you to indicate that the procedure that we have been following is not for us as members to kind of express, personal or organizational views, but more, this is a public hearing. So we've heard some very interesting and thought through presentations today. But if you don't mind, Chair, just one or two comments. On the first one, I don't know if Michael gave his surname, but he just said he's Michael. That's not really important. But in Michael's input, I was in the beginning looking for the actual motivation, but I see that in terms of the very interesting and concerning narrative that he's told us around the issue of the steel mill, that he is basically motivating for the commissioner, or at the very least, a watchdog for sustainable development. So, but I mean, it's not our responsibility to deal with this, but I think one of the resolutions we should consider is that this problem really needs to be escalated to all spheres of government. And if there is, I don't know if there is actually the organization called Save Kale's River, if that's like the structure that Michael and others are involved in. But I think if at all possible, Chair, we should look at trying to get that organization to have a meeting with the different spheres of government on this issue. And then the second thing is, in terms of Mr. Wiley, that was a very interesting perspective, I think, for many of us as well, given Mr. Wiley having been a chief whip before, his interest in environment and a number of the issues that he's raised. I think the one issue is that, as I heard, and possibly Mr. Wiley can just clarify this, I think because he's an old hand and he understands how legislation works, that I think I heard Mr. Wiley saying, although one might consider, I mean, he's moving it's from a clear position that the environmental commissioner should be appointed. And then he's arguing, as I picked it up, and it would be useful if we could also get the presentation, that to maintain the current functions of the environmental commissioner as they currently stand. Because I think, as I heard it, he was saying that if one then goes through not just, because I just want to inform the members of the public who might not be aware that the majority required to actually amend the provincial constitution is 2/3. And if I'm not mistaken, that's 28 members of this House, and there's different political parties who have different numbers. So I think it's quite important for people, not if they're part of parties or whatever, besides lobbying us, I think people should also lobby their own political parties on this issue. The party I belong to, we've got a clear position in support of it, of keeping the commissioner, but I think people, should see that. But what I'm getting to is that, and what's interesting as well, and I think in terms of the concerned federalists, I mean, I'm just almost done. Just to say that the experience that we had with the Children's Commissioner is that this Children's Commissioner or the Environmental Commissioner cannot just be nominated by a simple majority of this House. In fact, 60% of the members of this House have to agree on the Commissioner. So this isn't a politician. This is like someone, I mean, there was interesting ideas about retired judges, but it's interesting if we are able to succeed in keeping the environmental commissioner, we would then have to draft a law, and there is already a draft law which was put on the back burner. But the issue that arises, and I wanted to ask Mr. Wiley, is the motivation for keeping the powers as they are and not possibly increasing the powers? Is it more a concern that you're worried about the time that it's going to take? Because my only issue in response to that is, for instance, what we in our study group of our caucus have been thinking about. I mean, just a broad issue of the issue of climate change. Now, obviously, I'm not saying climate change wasn't an issue in 1978, but if the commissioner's function could also be to advise the province on steps which can be taken to mitigate climate change, as an example, that would be a new power. And the issue for me would then be, because I think the independence for me, which is one of the strongest arguments, you've got all sorts of competing interests. You can call it capture, attempted capture, all sorts of things. Whereas if you get the right person, and as others have said here about why people come to our province, I think there's many reasons, including our natural environment, is that if you also inserted the issue of climate change advice to this legislature, you hopefully would get a view that is conscious, for instance, about the impact of climate change on people's lives, or if you move too rapidly towards a non-carbon economy, how that affects workers. I mean, we're having a whole debate about Eskom and moving towards renewable energy and plans to retrain those workers, et cetera, et cetera. But if you had someone with a clear focus on the issue of climate change, then they'll speak to the farmers, they'll speak to the business people, they'll speak to the environmental lobbies, et cetera, and hopefully, because in all of this, choices have to be made and compromises have to be made. But for me, and I just want to ask, if we now finally, 24 years later, finally getting to this point, would it not be useful to take a little bit of time, because we're going to have to draft a provincial law anyway, to look at those powers? But I suppose the powers which are there, are immediate, because it's now about whether we change this constitution or not. But if we look at the issue of adding 1 or 2 more powers, that's what we're able to do. If 2/3 of this House says we should have, and I'm just using an example of another function to advise the provincial parliament about climate change mitigation strategies on a yearly basis, a simple clause. Then if we delay that, then how long is it going to take again? So maybe Mr. Wiley's got a response to that. And then Mr. Jabaza made a very strong point about the issue of money bills. And I'm just saying, Chair, that we should possibly consider, obviously it's not directly related to the Constitution, but for 24 years, we haven't had a law which allows us to change a budget. And I think he made some very interesting arguments about how it would force political parties to say, well, what's happening in Kales River or Khayelitsha? What is this community actually benefiting? Because at the moment, we get a budget. We can either support it, can vote against it, or we can abstain. We can't change a money bill. So it just becomes like a sort of a, I don't know what Mr. Wiley's view on that would be, but it becomes just a tick box exercise and so on. So I'm glad that that point has been raised as well. Thank you, Chair.
Thank you so much. In the spirit of fostering the engagement, when we can gather in a public hearing, when one political party can nominate an acting chairperson and then it's seconded by a totally different political party, where we want to work together. So thank you so much for your input. I am going to ask if there's any member that is online that would want to make any comment at this time. I am checking the time, and this is a very interesting time for South Africa. So I am going to allow speakers, if there's any further comment that any speaker would want to do, for a time allocation of 60 seconds. But let me just double check. Members, are you covered online? I trust that members are covered online. Any person that have made...
Yes, thank you, Chairperson.
Are you covered, Member Philander?
Thank you, yes, Chair.
Member Bartman, I note your hand.
Thank you, Chair. I wasn't sure if the hand function on my side was working. No, Chair, I share the one comment regarding the money bills. And I know it's not in this particular committee, but over the past year, I do want to let the acting chair know that the budget committee has been actively working towards research towards a money bills process. And we are even having workshops on this so that we are all knowledgeable on the various different content from the various different departments. And that resolution at that time, I think it was the first or second budget committee of our term, was unanimously supported after introduction by members Mackenzie, and Member Philander is also a member of this committee as well. And I just would like to assure the acting chair that we are trying our best to work towards ensuring that not only does such a bill become the best type of money bills in the South Africa, but that it essentially becomes one of the best in the world, and that others come to us in order to seek advice on engagement regarding finance and money bills legislation. But that is a work in progress. Unfortunately, the legislation does not get drafted overnight, but I would like to assure the acting chair that that is currently in progress, and the whole committee of budget has unanimously supported the respective resolutions over the past 2 years. Thank you.
Thank you so much, Member Bartman. Is for those of the members that are online and members of the public, Deborah Bartman is our chairperson for Finance and the Budget Committee. Thank you so much. I trust that Member Dagmar will be satisfied by that comment. Members of the public, 60 seconds. Is there any hand?
You said all someone spoke. They want to speak.
Yes. Is there any person? Mr. Michael, are you covered? By the end of this public hearing, I would be able to pronounce your surname, sir. Is there anyone else? Mr. Wiley, are you covered?
Yeah, no, I am. Thank you. Mr. Dugmore raised a couple of things, but as I said in my presentation, 24 years has passed. Events have overtaken certain aspects. The world has moved tremendously in that period of time. And I think that the Werkswijze, the terms of reference of an environmental commissioner needs to be looked at. But I do believe that given the urgency with regard to the holistic climate environment, I mean the environmental debate, that there is definitely a need for that. I mean, all world governments are moving in that direction now.
I'm looking across the floor. I see Mr. Diabaza, your hand is up.
Thank you, Chairperson. Chairperson, I just want to make one last point. Can you hear me, Chairperson?
We can hear you, sir.
I don't know whether, Chairperson, the Western Cape government does monitor, the bulk alienation or sale of prime land in the Western Cape as we are speaking. A lot of these municipalities are alienating important pieces of land, and also the coastline is being given to some farmers, that are close, and some developers close to the sea. As a result, the public does not have access to that. I wanted to maybe to canvass, Chairperson, that can't we have a process as you consider this environmental commissioner by which you get an audit, or some information from different municipalities. I think the public is under siege. Thank you, Chairperson.
Mr. Diabasa, thank you so much. I see Mr.
30 seconds. Yeah, Chair, if you could just clarify to the public, and if you could just clarify to the public and whoever is watching the issue of written submissions. And clearly it would seem then that for written submissions, the proposals to strengthen the environmental commission are also welcome. Is that correct?
Yes.
So if, in other words, someone wants to come with a clause or two, they can, and whether the committee accepts it or not, and the point that Mr. Wiley has raised, whether to go with a limited thing or not. But I think it would be useful if the inputs that we had, got advocates here and others, if they can also know that besides commenting, they can even propose. But maybe that would, because it has to be the constitution, it can't be the law. If this goes through, if you want to strengthen, it will have to be amending the provincial constitution, keeping the commissioner, but adding if we want. Yeah.
Thank you so much, Member Dagmo. I will cover that now, Member Brontes.
Thank you, Chair. I'm not going to take advantage of the situation that the public is present today, but we want to make it clear, and we want to take the position that the Al Jamaa Party will most definitely support the appointment of an environmental commissioner. Thank you, Chair.
Thank you so much to members of the public and those that are tuning in online. Written submissions as per the act is open until the end of May. The committee resolved in order to undertake further public.
Bye-bye. Member Ellen moet maar nou saam met my kom.
Can you hear me? So sorry. Okay. Can we mute that member? Members? Yes. Members of the public and those that are viewing online, as per the act, a number of public hearings were scheduled. We have a dedicated WhatsApp line in order for members of the public to either send a voice note or to send a text message via WhatsApp in order to facilitate public involvement and engagement. And that number is 082 372 7463. I repeat, it's 082 372 7463, or you are able to email our procedural officer, and her email address would be WACHMAT, I repeat, WACHMAT@wcpp.gov.za. I will further request via our social media team to share the advert once again so that members of the public are encouraged to participate and to engage, and for those written submissions to be filtered through to the committee. For those that would know, we would then undertake it in the form of a matrix where all the comments will be taken into account by the committee, and we will move forward from there. But directly hereafter, members, if you are able to stay behind for 5 minutes to just conclude our resolutions. Before we adjourn, I am going to take Mr. Frank Raymond.
Thank you. Let me make clarity. The submission that we've made, must we do it in writing, or is our submission to? Do you need 2 submissions?
We have noted your submission, sir, but you are more than welcome to add any written submissions further to that regard. That will be appreciated. Members of the public, to the department, thank you so much. You've been on a journey with the committee through various towns and now in the city of Cape Town. It is highly appreciated. Thank you so much. To those that are viewing online, your presence is valued. Mr. Mark Wiley, your voice still echoes in this chamber, sir. Thank you so much for your attendance. Mr. Raymond and Co, PMG, thank you so much. Ma'am, thank you so much for your presence here today as well. This meeting is adjourned and there is refreshments right outside down the lobby in the lounge area. It is COVID compliant and you are more than welcome to grab a pack and a glass of water or coffee. Say coffee. And there's coffee. Thank you so much. Yes. We will probably get him still outside. Member Brunkes and Member Dagmore, Member Bartman and Member Philander. In terms of our resolutions, I want to put to the committee that we invite our public education and outreach committee or directorate in order to brief the committee on the processes that they undertake prior to a public hearing. Is that in order with everyone? And thereafter, the chairperson will engage the programming authority in order to confirm the dates, and then that will be communicated accordingly to the members of this committee. I trust that you find that in order. Member Gago, based on the chairperson for finances input on the money bills, I trust that you are covered in that regard.
Yeah, well, I think it's just really for information. I mean, our concern is the length of time this is taking, but I think that's a matter for the budget committee for now, so don't.
Thank you so much. Members, on that note, we are covered. Member Philander, I see you, ma'am.
No, thank you, Chairperson. I just wanted to support your proposal in terms of outreach as well as the indulgence of the programming authority. That's all in order. I support that proposal, Chair.
Thank you so much.
Yeah. No, Chair, yeah, also not, I don't want to sort of make a huge issue of this now, but just to inform you in case you were not aware that, remember when we were in the Southern Cape, we had decided to see how we could get members of the public to participate even through data or going to libraries or two-song centers and so on and so forth. And they just seemed, and I'd been engaging with the committee coordinator as people had sent me their details for wanting to participate. And then all of a sudden, like, we sort of started picking up a problem even yesterday or this morning, where the administration then said that, no, this is not possible. And eventually what happened is that I then offered to give the data to these individuals who've approached me on the basis that I would then claim it back from the committee. And there was lots of toing and froing, and eventually that's kind of what transpired. But I think why it's important, and maybe this is a matter for the Parliamentary Oversight Committee, is really to put in place a proper policy. I mean, you can save so much money. You don't want to do it in a party political way, but if our adverts that go out and that unit that goes out also says to people, if you'd rather do this in your home, we might have a limit of 20, the first 20 people who want to get the data or and don't have access to a two-song center or a Cape Access Center, whatever the policy is. But I mean, eventually I did it, and I'm trusting that Wasima will make sure that I get refunded. No, I know she will, but it was just unnecessary, you know. And so I want to propose that, you know, we do have a discussion as a committee about the experience that we had, and then we consider, you know, asking the Parliamentary Oversight Committee to develop formal policy on this matter.
Yeah.
Okay, that's a proposal.
Now, that makes sense that we are able to then draft a letter to the POC regarding a SOP or a way forward in terms of the public participation process and then the data. That would be okay. I've also noted, members, that we need to resolve on the extension date, which will for now be extended indefinitely as we are still needing to finalize the dates so that the comment section does not close 31 May. I trust that members find that in order. Member Branches?
Thank you, Chair. In terms of the Saldanha Bay resolution, I propose that if the committee, if the next public hearing could be in an area called Sunflay. For Sunflay is an area that is opposite environmental disaster taking place. So I just wanted to make sure that the Chair takes note of that and
Yes.
it is noted.
It's in the minutes previously.
Yeah, thank you.
Thank you so much, members. So the extension is indefinitely as we need to engage the public and the programming authority and to confirm those dates. And on that note, once again,
Just to what Professor said, I thought the decision was that the Saldanha minute in order that is going to be circulated so we could all informally say yes. But I'm definitely support the Sunflay one. To be honest, I don't think we need another 3, but that's fine. I definitely need this one to be another one in the metro. But I personally, I don't think we need another 2. So if that draft Saldanha minute can be circulated,
okay.
Just comment,
I will direct, I will during the course of this week still engage the chairperson in this regard, and you will then ultimately write to the programming authority. So thank you so much, Member Dagmo, Member Brinkhuis. I feel humbled that you have nominated me.
Member Philander and Member Bartman that we're going to nominate Member Brinkhuis, and then the next time then we're really going to start trusting each other.
Okay. Thank you so much, Member Bartman. Thank you so much for your attendance here today. Member Philander, our IT support, our legal advisors, Mr. LaRue, Advocate Mastor, Lizette Kluter. Thank you so much to the amazing Wasima Ahmad Kamish. Thank you so much. Siraj, bye bye, dankie. Members, this meeting is now adjourned. There is coffee and refreshments. And